the aspiration towards intimate knowing, the intimate knowing of oneself and others, is a creative struggle towards redefining property. What the hell does that mean?
Senator.
Thank you, Mr. Chairman. Judge Ketsubai, I think your fellow nominees owe you a debt of gratitude because many Biden nominees have been extreme, but your record is so far out of the mainstream that you have attracted virtually all of the questions. I was particularly intrigued by your statement to Senator Blackburn that you said you are not, in fact, a Marxist. And then you said, and I wrote it down, I have not praised Marxist ideas. Now, as you know, in law, there is the fact of evidence. And so let's go to something you wrote, an article that is entitled Centralized Property Theory, in which you wrote, it begins, it's on the front page of your law school newspaper. You write, quote, intimate knowing, the lovers kissed, familiar and ever exciting, passionate transcendence. Beyond the physical exhilaration lies a burning light in our limbs, our hearts. Floating, flying, falling in every direction, amorphous and wonderful, time-stretching, space-curving, exquisitely explosive eros. And yet I timidly tremble every time. Now, somehow this is about property, which is not immediately evident as to why, but later in the article you write, you say, property is not simply a relationship between an owner and an object of ownership. Property is primarily a complex relationship between people and secondarily regards the objects people exploit. Historically, three paradigms have dominated European notions of property. Locke appealed to the notion that labor points to who has the right to exploit property. Bentham relied on utility to dictate who has rights based on how the property is exploited. And Marx was plainly disgusted with the alienation that property imposed and its establishment of an us and them and haves and have-nots. Each theory alone denies important components of human experience. Among them are the ability to work, the need for personal privacy and boundaries, and uniquely diverse desires which spin us all in differing life directions. However, the process towards integrating all three may provide a framework for relationships that enhances each unique self. The aspiration towards intimate knowing, the intimate knowing of oneself and others, is a creative struggle towards redefining property. What the hell does that mean?
Senator, when I was preparing and reviewing my materials for this hearing and for the process, I also have to admit that that writing was far from clear or articulate, and the poetry was definitely not good. Now, Senator, I don't make...
Do you believe we need to have a creative struggle towards redefining property, which is what you were advocating for?
That was something that I wrote 30 years ago, Senator, and in the course of just exploring law school and the ideas that came with...
Okay, so your flirtations with Marxism were 30 years ago, so let's go more recent. In 2020, you gave a speech entitled Reflections on Equity and Privilege, and you said, quote, first, the world is wide enough for all of us. Privilege derives its power from the belief in scarcity, scarcity of money, natural resources, food, and power itself. The desire to control it all drives privilege. I want to suggest to you that equity, the idea of equity, rejects this model of scarcity. Now, that's Marxism in 2020. What did that mean?
I've never considered that to be Marxist, Senator. It's the idea that equal access, and in the context of the work that I do here... So
there is no scarcity, there are no property rights. Equity gives everyone an entitlement to each other's property. Is that right?
Not at all. And in the context of the work that I do on the bench, Senator, when you look at my record for all of these 16 years, you will find that I have upheld the Constitution and our case precedent.
Okay, well, let's turn to something else you wrote in the Wisconsin Women Law Journal. Again, this is your writing. The name of the article is Destabilizing Power and Rape, Why Consent Theory and Rape Law Has Turned on Its Head. You cited Professor Catherine McKinnon, who argued, quote, sexuality itself is a power web in which heterosexual relations per se are infused with violence and control, and, quote, most intercourse is rape. Now, her views are extreme, and yet, and when Senator Blackburn asks you about them, here at the hearing, when you want to be confirmed, you try to distance yourself from them. But here's what you wrote in the article. You embrace those views. You wrote, quote, I employ the view that rape is sex in order to focus on the significance of consent in rape law. The Sex Act is a violation per se without consent. In order to properly align the consent doctrine in rape law with consent in other areas of law, non-consent must be presumed. Do you believe that is a mainstream view, that heterosexual sex is rape?
Senator, in that article, I was exploring different ideas and theories, and I was employing the hypothetical that you've just described to try to tease out a particular issue with respect to consent. With respect to your last question...
So you also quoted Professor McKinnon, who wrote, quote, sexuality is to feminism what work is to Marxism. Let me ask you again, what does that mean?
Senator, I was summarizing different theories that people were presenting, so that way I could explain them and then employ an analysis with respect to the issue of what consent was in the context of sexual assault back in 30 years ago.
I think your views are far, far out of the mainstream.
Thank you, Mr. Chairman. Judge Casaby, I'm looking at an order you issued as a magistrate judge here, requiring the use of pronouns in your court. Do you require the use of pronouns, the declaration of one's pronouns in your court?
Senator, that may be referring to perhaps a trial management order or a scheduling order of some kind?
Yeah. No, it's a statement. You issued it. Here it is.
It's an invitation for people to identify their pronouns and or their honorifics.
Well, I'm looking at your requirement that you issued to all people in your court. You say, quote, when you introduce yourself in a meeting, you should say, my name is Judge Blank and my pronouns are blank. Is that right?
Senator, those were not requirements or rules. Those were suggestions and
They were suggestions.
Those were suggestions and invitations for people to use.
And you also, in your directive, you say, quote, I'd like counsel to introduce themselves giving your full name and your honorific, such as Ms., MS period, Mix, or Mr., not Mrs. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., MS period, Mix, or Mr. End quote. Is that right?
Senator, it's not a directive. Again, it's an invitation for people to introduce themselves.
Invitation.
Yeah.
Okay. All right. I'm looking at an article from the Oregon State Bar Bulletin from May of 2021. And I want to read one of your quotes. Quote, we have to set aside conventional ideas of proof. Let me say that again. We have to set aside conventional ideas of proof, you said, when we are dealing with the personal and interpersonal work of equity, division, and inclusion. As a judge, I can appreciate the challenge of employing a different mode for understanding truth than that which most lawyers are accustomed to in our work, end quote. Did you write that?
That is a quote from that article.
So when we're dealing with equity, diversity, and inclusion, we should set aside conventional ideas of proof. Is that right?
In the larger context of interpersonal and personal relationships, the idea of being able to have a conversation with somebody.
Yeah, but you didn't talk about a conversation. You said proof.
It's in the context of having a conversation with somebody about the issue of their background and their experience.
When the issue is equity, diversity, or inclusion, we should have a different set of proof. Is that right?
When it comes to the space in which people have interpersonal relationships with one another, the idea of respecting and dignifying each other with their experiences is an important part of...
So all issues have one set of proof, which has been handed down by our state Supreme Courts, our U.S. Supreme Court, except you think we ought to have a different set of proof when equity, diversity, and inclusion are at issue. Is that right?
In all of my years on the bench, Senator, I have applied the law, the rules of evidence, the case precedent.
Let me move on. I'm looking at the notes you gave us from a speech you made in February 7, 2020. It's entitled Speech Reflections on Equity and Privilege to the Oregon Blacks in Government. You wrote, quote, "White, male, straight people allow privilege to remain in place," close quote. Did you say that? Did you write that?
Without looking at the specific speech
here. You turned it in.
Well, if that's on the piece of paper, Senator, then I have no reason to disagree.
You also wrote, quote, "Privilege is incredibly similar to narcissistic personality disorder," close quote. Did you write that?
Without looking at everything in the context of that statement, it appears correct.
Okay. You wrote, quote, "The identity of Muslims also need to be normalized in a country that is so deeply Islamophobic." Did you write that?
Senator, I did. And what I'd also like to clarify is that in the context of my work on the bench, I have treated everybody equally without regard to their background.
Sorry, I just want to get through this. I'm going to run out of time. You also wrote, quote, "I am disappointed about the way in which the founding fathers of this country perpetuated inequity," close quote. Did you write that?
In the context of the issue of slavery, that was something that I'd been considering.
In your notes you gave us from a speech on May 17, 2023, "Does race matter?" You said, quote, "Does race matter? Hell yes," close quote. You know that T-shirt at the Saturday markets, the one that says something like "Love, see no color," and it has all the colors of the rainbow all over it, and it's like a tie-dye shirt. Well, the first time I saw it, I said, "Ah, how sweet." Then I got angry. If love doesn't see color, then I don't have allies, close quote. Did you say that?
Yes, and that was to explain that the work of equity is to help understand where people are coming from, not to ignore who they are.
And you also... Yeah, no, I'm sorry. Can I have 30 more seconds? Judge, you seem to be obsessed with race and sexuality. I mean, you even go so far as to say that when race and sexuality and diversity and inclusion are at issue, we need a separate standard of proof in the United States federal judiciary. How are litigants going to be able to trust you?
Senator, that's not what I've said. There is no different standard.
It is bigger than Dallas. I read it to you.
When you look
turned in these documents. I didn't go looking for them.
When you look
proud of it.
As anyone who reviews my record on the bench,
I have
thousands of cases.
I'm going to let you finish responding, and your time has expired, but go ahead.
The rule of law is an absolute for me. The work that I have done on the bench over the last 16...
That's not what you say.
The work that I've done on the bench...
But that's not what you say.
Judge, finish your sentence.
The work that I've done on the bench in ruling over all the people's cases that have appeared in front of me from all backgrounds, of all faiths, you'll find that I have upheld the rule of law and upheld the precedent of our Constitution and our Supreme Court and the Ninth Circuit.
Well, if the chairman would give me time, I could go through the cases and prove that that's not the case.
Senator,
I just don't see how you can be a fair-minded judge.
Senator Graham.
Thank you, Mr. Kazabai. In 2020, while you were a magistrate judge, you apparently gave a speech stating that Ibram Kendi is an amazing historian and author, and he does important work in the history of the construction of race. You wrote a book, am I right, called How to Be an Anti-Racist?
Senator, I want to make sure I understood the question. I didn't write a book.
Or article? What was it?
I believe the author, Ibram Kendi, wrote a book about how to be an anti-racist.
Okay, I'm sorry, yeah. So you cite him in this speech, and here's what he argues, that the only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination. Do you agree with that?
Senator, discrimination in the treatment of treating anyone negatively is not appropriate, and our courts, through the Student for Fair Admissions, has also clarified that as a national guidepost.
So you don't agree with that?
The statement that you meet discrimination with discrimination is not part of what our courts should be upholding. It has been clear in our guidance from the Supreme Court as well.
So you do not agree with Mr. Kendi's proposition as I read it to you?
That is correct.
Okay. Tell me about is it a pamphlet of your court? I think you created Pronouns in the Court Guide. Tell me about that.
I developed what's often called sort of a cheat sheet for the bench of just the simple prescriptions or language that I could use to ensure access to the courts, that everybody who comes before the court can be acknowledged and identified in dignified ways, and that related to the issue of the use of pronouns and honorifics, such as Mr. or Miss or Mix, and for that matter, Mrs. And so I invite people, when they come to court and introduce themselves, to offer their identity in the way of their honorifics.
Is that practice used by other judges, or do you know?
I know that other judges identify their pronouns, for example, in their signature emails, and that other judges throughout the state in Oregon encourage people to identify their pronouns when coming into court, so they also can ensure that people are dignified by identifying themselves in the courtroom.
I can't say the name of I guess it's the plaintiff here. Somebody versus the city of Eugene. Are you familiar with that case? Boudjerada.
Buddha.
Yeah. That case, did that case come before you? Did you rule that Eugene, Oregon's citywide curfew in response to rioting and looting and acts of violence was unconstitutional?
Senator, under the First Amendment, and that was the structure and the analysis in that case involved a time, place, and manner restriction on protests.
Do you think you appropriately applied existing precedent of Oregon law to this case?
In every instance, Senator, I strive to apply binding precedent from the Ninth Circuit as well as the Supreme Court.
Well, this one to me seems like legal gymnastics to get around the most recent case in Oregon, but that's just my opinion. Further along, in this same case, you recently ruled, I think, Eugene's city manager and police chief are not entitled to qualified immunity regarding their decision to implement the curfew. Is that correct?
In that follow-up opinion, after analyzing the issues of First Amendment and the time, place, and manner restrictions, I subsequently considered the issues with respect to several 1983 claims against individual officers, as well as the chief of police and the city manager. In that opinion, I found that the individual officers were not subject to suit because of qualified immunity. But
well, I didn't ask you that. I asked you about the police chief.
And with respect to the police chief and the city manager, with the actions that were taken in light of what I determined to be a
Right.
a
you.
clear violation of a constitutional right.
One last question. How would you describe the violence and the destruction of property in Eugene, Oregon? How would you describe that?
Senator, violence and destruction of property anywhere
Would you consider
is...
it riot? A riot?
Senator, the facts before me were involving the issues of whether the citywide curfew, as opposed to a curfew within narrow boundaries, was constitutionally appropriate.
I would encourage my colleagues to look at this particular scenario and make your own decision whether or not a curfew was justified. Thank you.
Thank you, Mr. Chairman. Thanks to all of you for being here and for your willingness to be considered for these important positions. Judge Kasuba, I'd like to start with you, if that's all right. A few months ago, in May of this year, you gave a presentation to the Oregon State Bar in which you included the following in your remarks. Quote, DEI, diversity, equity, and inclusion, is the heart and soul of the court system. Can we say that? Yeah, I just did, and I say it proudly. Mr. Kasubai, Judge, could you explain what that means?
Yes. Access to justice is at the heart of the work that I do within the courtroom, and ensuring that everybody is dignified and treated with dignity when they come into the courtroom, and for me to preside over those cases.
But you'd say that's the heart and soul of the judicial system, more than equal justice under the law, more than the Constitution, more than the law itself, or the job of interpreting the law fairly, where litigants before you have disagreements as to the law's meaning.
In the way in which, and in the context in which I was using the term and referring to diversity, was the idea and the ideal of equal justice under the law, that everybody, no matter what their background, beliefs, whatever that might be, that everyone is entitled to access to the courts and that equity.
All right, let's circle back to that one in a minute. The First Amendment's protection of free speech is foundational. It's been described as one of our first freedoms. It's been described accurately, I think, fairly, by many as being upstream from all of our other rights. And it has to be protected vigorously. And we also know that there are time, place, and manner accommodations that can go along with that. Among other things, there are special exceptions that occur where riot control measures are necessary due to an outbreak of coordinated, overt violence. In a case that's been referred to briefly in the hearing today, but not much, this Bujarata versus City of Eugene, you're dealing with some interesting circumstances. You had riots taking place. There were 3 nights of terror in Eugene, Oregon, during the BLM riots of 2020, where, in your words, the following was going on. Quote, a crowd applying graffiti, lighting fireworks, and blocking traffic, throwing glass bottles towards officers surrounding a patrol car, smashing its windows and puncturing its tires, with the officers inside the patrol car, mind you. The group, quote, started fires in the roadway, attacked people and vehicles in the downtown area. Several businesses were vandalized and looted, and several officers were injured. You went on to state that members of the group carried heavy backpacks and bottles and were communicating via radios. So in response to this, the city implemented some riot control measures. They imposed a citywide curfew, one that lasted 7 hours. We had 3 rioters who were arrested during the curfew, and despite the Ninth Circuit precedent in the Mariotti case, the Minotti case, addressing a very similar curfew in Seattle, you decided that the Eugene, Oregon curfew was unconstitutional. Can you explain to me how, consistent with the Ninth Circuit precedent in the Minotti case, how does a 7-hour curfew through the middle of the night in the wave of such destruction and terror prevent ample means of communication? Can you explain that to me?
The Minotti case did provide guidance and assisted me in evaluating the legal analysis that I applied. There were 2 curfews that had been imposed. One was a downtown curfew, so there were geographic restrictions. That was not the curfew that was before me, nor did I find that unconstitutional. It was a citywide curfew that actually subjected everybody in the city, well beyond the boundaries of downtown, to out into the residential neighborhood, such that the application of that curfew, that citywide curfew, could have criminalized people's behavior of just trying to get home, well outside of any of the riots and the protests.
You've praised Ibrahim X. Kendi as someone who you like, as an amazing historian and author, and you said that you would like to push some of Ibrahim X. Kendi's ideas even further. I'm sure you're aware he's famous for saying, quote, "The only remedy to racist discrimination is anti-racist discrimination. The only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination." Kendi also stated that in order to truly be an anti-racist, you have to be anti-capitalist. So I'd like to know, first of all, what would you do to push Ibrahim Kendi's ideas even further? And do you believe someone should be praising, someone who is currently a federal magistrate judge, be praising someone who encourages discrimination in any circumstance?
Senator, I don't recall having ever remarked that I want to push Ibrahim Kendi's ideas further. In questions earlier in this hearing, I clearly stated that the ideas that have been described here that have been attributed to Ibrahim Kendi are not ideas that are consistent with the 20 years in my public service, 16 as a judge, and the record that I have shown striving to apply the law, the Constitution, and Supreme Court precedent. Would not be consistent with this idea of supporting the ideas that you've described as Ibrahim Kendi's.
So you're saying that you have never said that you would like to push some of Ibrahim Kendi's ideas further?
So I don't recall having made that particular statement.
Okay. I see my time has expired. We'll follow up on these in writing. These are concerning one of the most fundamental laws we have that's embedded within our Constitution, is that governments can't treat people differently on the basis of their race, and that's why this is important to ask about. Thank you.